Justice Emeka Nwite of the Federal High Court in Abuja has directed the Independent National Electoral Commission, INEC, to recognize Mr. Olusola, Nehemiah and Ezekiel Awude as the Labour Party's governorship and deputy governorship candidates for the upcoming Ondo State election. The ruling came after Nehemiah and Awude filed a joint suit against INEC. Justice Nwite declared the second Labour Party primary election, which produced the duo, as valid, confirming that INEC must uphold its results. The court noted that Nehemiah had paid 20 million naira for the nomination form, and there was evidence he had been instructed by the party to pay 5 million naira to Olorunfemi Ayodele Festus upon. Justice Nwite criticized Labour Party leaders for disowning the valid primary election and ordered INEC to publish the names of Nehemiah and Awude as the rightful Labour Party candidates for the Ondo State governorship election in November 16. To discuss this, we're joined by a legal practitioner and public affairs analyst, Vincent Ottaokpukpu. Thank you so much, Vincent, for joining us on the news.
Thank you for having me. Thank you, our wonderful audience.
Yes, you're welcome. Now, how significant is this court ruling for the Labour Party's internal structure, especially considering the dispute over the second primary election that produced Nehemiah and Awude?
Okay, thank you for having me once again. The judgment of the court is well founded in law, founded on law in the sense that the court brought to bear interpretation of various provisions of the Electoral Act and the Constitution of Nigeria that empowers and lawfully, empower the political parties to substitute their candidate. Recall that the Labour Party had previously conducted a primary election in which the candidate emerged and whose name and deputy was submitted to INEC as their governorship candidate for the Ondo Governorship elections slated for 16th of November 2024. But I wouldn't call it a placeholder or whatever, as the case may be. But the fellow voluntarily withdrew. And the court was invited by the plaintiff to interpret section 29 of the Electoral Act, which says sub 1 that a political party that have conducted their primary election shall submit lists of candidates to INEC not later than 180 days to the date of election. So the Labour Party complied. Now, section 30, the court was also invoked to interpret section 31, of the Electoral Act, which states that a candidate nominated and whose name has been submitted to INEC may withdraw his nomination in writing in a prescribed form by notifying his political party. And the political party must now notify INEC not later than 80 days, I think 80 or 90 days to the election. The Labour Party comply with this. Now, section 33, which was also called for interpretation in that judgment, states as follows: that a political party shall not be at liberty to change or substitute their candidate unless for voluntary withdrawal or in cause of death, provided that such political party is allowed to conduct a fresh primary within 14 days of such events, and wherein they will elect a new candidate.
Okay.
So the Labour Party conducted primary and submitted a candidate to INEC, but the fellow wrote a letter and withdrew his nomination. The Labour Party communicated to INEC to that effect and held a fresh primary election on the 18th of July, 2024. Now, which the fellows that went to Federal High Court emerged as winners.
Okay.
And that decision was communicated to INEC on the 24th of July, 2024. But INEC failed, refused, and neglected to recognize them as candidates and refused to publish their name on the website of their website as duly elected candidates having been substituted.
So, Vincent, will such a judgment in any way affect INEC's role when it comes to overseeing party primaries and managing disputes when it comes to candidates' nomination moving forward from here?
No, it will not affect INEC. What the court has done today is to interpret the provisions of law and compel INEC to obey the provisions of the law. which itself regulates their functions and duties under the Electoral Act. So it will never in any way affect the responsibility of INEC. And I know the choice of candidate of any election is the prerogative and sole right of a political party. The Supreme Court have decided in litany and cornucopia of cases that party nomination is an internal dispute affair, internal affairs of a political party. Our responsibility of INEC under Section 153 of the Electoral Act, Section 153 1F of the Constitution of Nigeria, Section 2 of the Electoral Act, and Section 15, paragraph at 1, third schedule to the 1999 Constitution, does not include nomination of candidates or interference in the political affairs of political party in case of nomination. Now, the only aspect is that Section 84 sub 15 says that if a political party fails to comply with the requirement of nomination under Section 14, that their candidate should not be included. But that was not under interpretation in the context of the judgment we are discussing today. So that judgment is well-founded, and it will never in any way infringe on the powers of INEC or right of INEC to monitor activities of political party under Section 84 or as the case may be. Because remember, the 84 has made it mandatory for INEC to monitor primary election. But the case in question is not whether INEC monitor primary election or not. INEC monitored. What INEC said, the problem is that INEC failed to publish the substituted candidates' names in the website, which the court has compelled them to do.
All right.
So the judgment is well-founded. It has not need to infringe on the right and powers of INEC as an administrator of electoral activities in Nigeria.
All right, Vincent Ottaokpukpu, thank you so much for helping us understand this better. We may not have enough time to continue to talk more about this, but then we appreciate the legal angle in terms of your thoughts that you've shared with us this evening.